Hi, I'm John Council. I'm a senior reporter with Texas Lawyer Newspaper, and welcome to the December 22nd holiday edition of Reversed and Remanded. My guest today is Ernest Martin. Ernest is a partner in the Dallas office of Haynes and Boone. He's the head of the insurance coverage group at Haynes and Boone, and he's also a really cool guy because he's willing to wear the Christmas cap.
Ho, ho, ho.
Well, Ernest, believe it or not, I got some insurance cases to talk to you about on this holiday edition.
Of course.
We have our year-end edition coming out this week, and we have what we call the impact players, and we pick people in groups that had a significant impact on the law. So, one of the biggest cases that came out of the Texas Supreme Court this year was Frank's casing. It was a big insurance coverage case, and we decided, Ernest, that the group likely most responsible for that second opinion, which kind of got the law back, I guess, the way it should be on coverage, is the amici. And if you remember, Frank's casing is a case that when it originally came out, it was in 05, said that the insured, in some cases, could be on the hook for paying a settlement.
That's right. They could seek reimbursement of settlement costs that
Right.
they paid if later it was determined there was no coverage.
Right. So we had a bunch of amici writing the court saying, hey guys, you guys have really changed our world. Our settlements are now a disaster. We can't, I guess you can't, if you couldn't, I mean, well, how could you advise your client on what to do if you knew that money could be coming out of their pockets? What would you do?
That was the most difficult thing to do. After Frank's casing won, I think coverage lawyers were in turmoil because they did not know how best to advise their clients, because if they agreed to settle the case, in other words, they said to the carrier, we think you should settle the case, they were then subject to having the carrier come back and seek reimbursement.
Right, and that was the first case where the excess underwriters actually won that case.
That's
Frank's
right.
casing lost. So, what do you think that these amici said to change the court's mind? Was it the volume of them that got them to think about what the effects of the decision, or was it how it was written?
I think a combination of the two. Yeah. I think the fact there were so many briefs that were filed by different organizations asking the court to reconsider, that was number one. But number two, just the very practical issues that Frank's casing one rose, the problems that it engendered. I think that's what pushed the court to really step back and say, wait a minute, maybe we should rethink what we've done.
And Ernest, you filed an amici brief before, not in Frank's casing, but at Lamar Homes, was another huge insurance case where the court that was a certified question from the Fifth Circuit.
That was certified, yes.
Right. That wasn't like they had made a decision and then it came back to them. But I think that your brief, the court sided with your client, right?
Right.
Yeah.
Right.
Yeah. So we're seeing more of that. Okay. Second issue, new opinion out of the Texas Supreme Court that came out on Friday, and it's called U.S. F&G versus Godot, and this is another insurance case that, you know, Ernest, when I read the majority opinion, and I could just see the majority going, oh my gosh, we know we're going to get slammed over this opinion. And what it is it's a case where in the words of the majority opinion, they've got the most sympathetic plaintiff you could imagine. This is a guy that is driving down the highway, sees an accident, and pulls over to the side of the road to help a motorist in distress. Unfortunately, another motorist comes along, hits the back of this guy's car, and he is either pinned on top of it against a retaining wall.
Right.
But he had just gotten out of the car. Accident happens, and he gets severely injured. He lives. He does have insurance coverage, but the thing that's in question is whether or not the policy that covered him for underinsured motorists was effective because of the policy language. And the policy language said you have to occupy the vehicle. Now, that could be get in the vehicle, getting out of the vehicle, but if you're pinned and on top of the vehicle, are you occupying it, Ernest? What do you think?
Well, actually, the word was upon.
Upon.
It was upon, and I think all the parties agreed that that was the operative word.
Okay.
Whether or not he was upon the car.
Right.
Okay. And if he was upon the car, then he was occupying it. And if he was occupying it, then there was coverage.
Right.
Okay. And in my view, I think the court strained to find that he was not upon.
Right.
Because Justice Brister, who wrote
Right.
the majority opinion, acknowledged that if you looked outside the state and looked at other jurisdictions who had struggled with this issue, they were all over the board.
Right.
Which suggests to me that there was some ambiguity, or there was
Right.
there were at least two reasonable interpretations of this particular clause.
Right. Yeah.
So thereby causing an ambiguity, and thereby causing at least the argument that it should be interpreted in favor of coverage.
Right. Okay. Ernest's cell phone is singing a little holiday song here. All right. Okay. But you do this every day for a living. You fight these fights.
Right.
It's just amazing that they would quibble over this. I mean.
Well, it was not only that, but the fact that the insurance company admitted in a request for admission that that there was insurance, essentially.
Right. And that's what the dissent grabbed a hold of.
Yes.
Look, there was a request for admission where they said, yeah, there's coverage.
Right.
We should end our debate here.
Right.
So, goodness gracious. Okay. Now it's time to put Ernest in what I like to call the witness stand. I'm going to ask him some crazy questions.
All right.
And see what Ernest has to say. All right, Ernest, first question. Because of the type of law you practice, Ernest, do you pay the highest insurance premiums of anybody in Texas?
Well, they hate me, so I'm on a lot of blacklists, but I'm trying to, every time I apply for coverage, I use a different name.
Okay,
Yeah,
good. That'll
so
work. Yeah, okay. All right. Second question. Ernest, are you glad that Haynes and Boone just relocated to offices across the street from the American Airlines Center just in time for the Dallas Mavericks and Dallas Stars to become absolutely terrible?
Yes, actually, but there's a good side of this, and that is that we have a suite there,
Right.
so we can actually walk over there,
Right.
as opposed to having to fight the traffic. So
Right.
that's the plus,
Right.
being able to walk over to American Airlines Center and just being convenient.
Plenty of parking, however, just $20 if you want to park there. All right. Final question. Ernest, if you could just have one Christmas wish, would it be for an insurance company to accept a reasonable settlement offer, or that whole peace on earth thing?
Settlement offer.
All right. Honest lawyer. Thank you very much. Thanks, Ernest.
Thank you.
Thanks for coming over.
Take care. Merry Christmas.